Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. This week is a very crucial week for Mr. Kohberger as his replies to all of the defense's opposing responses to Mr. Kohberger's motions to suppress evidence, motions to compel discovery, and also for a Franks hearing. They're all due December 20th. Now, why aren't those replies due on the 27th of December or January 3rd? Well, it's because Judge Stephen Hippler set these deadlines and all deadlines in a pretrial and trial order that was rendered by the court on October 9th, 2024. And I wanted to go over some of the upcoming matters that have been established by that court order. Now, first, if you look for it on the docket, and October 9th, there were a number of filings, you will see one of them is entitled Redacted Order Governing Further Criminal Proceedings and Notice of Trial Setting. That is the pretrial and trial order. And what it says at page 1, it is hereby ordered as follows. Any prior scheduling order is hereby vacated. The following schedule will govern the pretrial matters outlined herein and the trial in this case. Now, what does Judge Hippler mean when he says any prior scheduling order is hereby vacated? Well, he's directing this statement primarily to the pretrial and trial order that was set by the prior jurist in the case, Judge John Judge. All of the deadlines, including the jury trial date that was established in Latah County prior to change of venue, are hereby vacated. They are set aside. This document now governs. This is the October 9th, 2024 order. Page 1 begins with voir dire and trial setting, and this has to do with the selection of the jury panel and the alternates, as well as when the trial starts. These dates are for further down the line, beginning July 30th, 2025, and will continue thereafter until November 7th, 2025, per this schedule. As these are for further down the line, would like to return with another episode of the IndieZoNe where we'll go over the matters that are set forth on page 1. I'd like to direct your attention at this time, however, to page 2, because this is where the more immediate deadlines are located. Page 2, Section B of the order is entitled Motions. Motions, again, application for a court order. That is what a motion is. The first bulleted item, the DP motions. All of these dates have come and gone. The rulings have been made on the DP motions. I want to now direct your attention to the next two sections. Discovery motions and Rule 12 ICR motions. The deadlines for both and for oral argument on both are exactly the same. So for the discovery motions and Rule 12 ICR motions, including motions to suppress evidence, they were due. The initial motions from the defense has come and gone. They were filed November 14th, 2024. Responses to all, December 6th, 2024. These were the filings that were just docketed on the 12th of December. These were the state's responses opposing everything that Mr. Kohberger filed November 14th, 2024. Replies per both are due November 20th, 2024. That is why we're looking for these responses to the state's responses, the replies this week. It's set right here in this court order, as are the oral arguments, also known as hearing, on all the discovery motions. The Rule 12 ICR motions, to include the motions to suppress, will be held January 23rd, 2025, and if necessary, the court has also reserved the next day, the 24th, 2025, but only if necessary. The last item are the motions in limine and notices under IRE 404, 608, 609. IRE is a rule of evidence. The motions in limine and similar motions are not due until February 10th, 2025 and further down the line. So I'll return to this in part 2 of this presentation on upcoming deadlines. But just briefly, a motion in limine would be something like the defense coming aboard and saying that Mr. Kohberger's past use of illicit substances, as we've learned about, we've heard about, there's been rumors about, should be kept out of the case. It's too prejudicial. It has nothing to do with the matters of whether or not he is guilty or not guilty of the 5 crimes that he has been charged with, all felonies, pursuant to the grand jury indictment that was returned and published on May 16th, 2023. This other matter has nothing to do with the state's burden of proving that Mr. Kohberger is the person who committed these crimes. It's too prejudicial, Judge. We want that issue to be kept out. That would be just an example as to what a motion in limine would be. And again, this is not until down the line. So I want to now direct your attention to a more immediate deadline, which is contained in C, discovery and experts disclosures. Now, number 1, defendant's discovery deadline is January 9th, 2025. So we can expect to possibly see perhaps a 21st supplemental request for discovery. The 20th supplemental request for discovery was filed last week by the defense. We are awaiting a response to that. Any further discovery-related matters that the defense feels it needs to obtain from the state of Idaho in the defense of their case has to get in by January 9th, 2025. So that is why we can expect to possibly see 1, possibly 2, maybe even more further discovery requests from the defense. Next section, experts. These are the expert disclosure. I would argue potential experts, because there are 2 sets of witnesses that you see at trial. The first are fact witnesses. These are people who saw things, who heard things, such as the surviving roommates. They have actual knowledge, per the Affidavit of Probable Cause, of relevant matters in this case. They're fact witnesses. An expert witness doesn't have firsthand knowledge. An expert witness is coming in to assist the jury with understanding other issues such as IgG DNA, the CAS data, information regarding the identification of suspect vehicle 1. Those would be individuals who are experts in the field, as suggested by either side, that they would like to bring forward and to provide testimony to help the jury make sense of some item that is brought forward in the case. I say that they are potential experts because the court has to make a decision even before trial as to whether a proposed expert is acceptable. Number 1, do they have information that's even relevant to the case? Do they have information that would help the state prove its case beyond a reasonable doubt, or the defense to defend against these charges? Is the information relevant? And number 2, is the expert truly an expert in the field, or are we dealing with junk science? Not all experts that are proposed get to appear before a jury. So therefore, that's why I say potential experts. A list of experts the parties intend to call at trial, including a copy of the experts' reports consistent with ICR 16b7 and a copy of the experts' curriculum vitae, shall be disclosed to the other side. So these are disclosures that the other party must submit. Now, let's look at this. A copy of the expert's report. This is where what the expert is expected to testify at trial will be disclosed. Just like you'll recall at the DP hearing that was held before Judge Hippler, the defense wanted to call 2 expert witnesses to help the court understand or to provide testimony as to what the defense's position were in the various motions. The court declined having either of those witnesses testify. And in Judge Hippler's defense, some people felt that he was being impartial. He really wasn't, because he already had the curriculum vitae and the report of what these experts were going to testify to. So he felt it was unnecessary, and he declined having them testify at hearing on the defense motions to strike the DP. Sort of the same thing here. Curriculum vitae is the resume. It's going to list all of the past experience, the skills, the knowledge, the credentials, what degrees this expert holds, their past current working experience, if they've published anything in academic journals, any honors that have been conferred, any memberships in committees or conferences or other types of relevant matters concerning the expert's background. With the report, that is what the judge will make this determination on, and possibly these experts will then be also called at a pretrial hearing. This is way before the jury trial even starts, and the judge will make a determination whether or not these people get to testify at trial. Now, the disclosures of these 2 materials, curriculum vitae and reports, are due. First, State's guilt phase experts, December 18th, 2024. Defendant's guilt phase experts, January 23rd, 2025. Going on to the next page, then we see when the rebuttal experts and when the sentencing phase experts, the deadlines. All of these deadlines, ladies and gentlemen, again, are for disclosures. And why is it that the state of Idaho gets to have 2 sets, the initial experts and then the rebuttal? Well, in the case in chief, it is the state of Idaho's obligation to prove to that jury that Mr. Kohberger, who is deemed innocent at every stage of the proceedings, from the moment of his arrest to the time that the jury trial starts and a verdict is rendered, he is considered innocent of all of the charges that are brought against him. It is the state's obligation, beyond a reasonable doubt, of the evidence proffered to prove every single element of all 5 of the felonies that he is charged with. So if it's their burden of proof, they get to present a rebuttal to the defense's proposed experts. Now, what names can we expect to see at trial? For defense, for example, I would expect that this is when Cy Ray is going to be disclosed. He was already made an appearance in this case for another matter while we were in Latah County. Now, if the defense still intends to call Cy Ray or whoever they intend to call at trial, this is when they disclose Mr. Ray's 1, curriculum vitae, and 2, what he is expected to testify to at trial. This will now conclude this episode of the IndieZoNe here on YouTube. We will have a part 2 where we're going to go over the rest of the items on this pretrial and trial scheduling order down the line. Until then, my name is Kathy. Thank you for joining us here today.